An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. The history of the 13th and 14th Amendments. To understand the history of the 13th and 14th Amendments, we have to trace their origins from the Constitutional Convention in 1787 to Dred Scott versus Sandford in 1857 to the Reconstruction period following the Civil War. Article 4, Section 2 of the Constitution states, quote, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." This provision prohibits states from discriminating against citizens from other states. Specifically, a state must guarantee certain fundamental rights known as privileges and immunities equally to its own citizens and to citizens from other states. But what are these rights? During the early years of the Republic, the Circuit Court case of Corfield versus Coryell in 1823 was viewed as the most important judicial interpretation of this provision. Corfield was authored by Justice Bushrod Washington, who was President Washington's nephew. He wrote the opinion while riding circuit from the District of Columbia to the District of Pennsylvania. Justice Washington explained that this clause protects, quote, "those privileges and immunities which are fundamental, which belong of right to the citizens of all free governments." In a lengthy passage of his opinion, Washington listed several examples of the privileges and immunities, including the, quote, "protection by the government" and, quote, "the right to acquire and possess property of every kind and to pursue and obtain happiness and safety." This formulation was originally drafted in 1776 by George Mason, who wrote the Virginia Declaration of Rights. Mason referred to these liberties as inherent natural rights. Mason's declaration inspired the Declaration of Independence, which Thomas Jefferson drafted a few weeks later. Massachusetts and several other states incorporated Mason's definition of natural rights into their constitutions. In 1783, the Massachusetts Supreme Judicial Court invoked this language to hold that slavery was unconstitutional in that state. In the 19th century, free black sailors were imprisoned in southern states while their ships were in port there. Abolitionists like Frederick Douglass argued that because they were citizens, their fundamental rights were protected by the Privileges and Immunities Clause of Article 4. The black sailors had these rights throughout the United States, even in slave states. The rights of people of African descent played a prominent role in Dred Scott versus Sandford. Chief Justice Taney held, even if a black person like Dred Scott could be considered a citizen of his own state, he could never become a citizen of the United States. And because free blacks were not U.S. citizens, they were not entitled to the privileges and immunities of citizens. In this way, Dred Scott introduced the distinction between national and state citizenship. Study Guide. Does the Privileges and Immunities Clause of Article 4 refer to citizens of the United States? To whom does it refer? To support this distinction, Chief Justice Taney speculated that Southern states would never have agreed to join the Union had they known that Article 4 of the Constitution would compel them to protect the rights of free blacks who traveled from northern states. Chief Justice Taney listed examples of privileges and immunities that Southern states would never have wanted extended to free blacks, including, quote, "the full liberty of speech in public," and the right to, quote, "keep and carry arms wherever they went." These rights are, of course, also protected by the First and Second Amendments, respectively. For Chief Justice Taney's argument to work, at least some of the rights protected by the Bill of Rights must have been thought to be privileges and immunities of citizens. Dred Scott invalidated the Missouri Compromise, which had attempted to maintain the balance between free and slave states. As a result, the decision helped precipitate a bloody civil war, which began just 4 years later. And it was this war that led to Dred Scott's repudiation. In April 1865, the Civil War drew to a formal conclusion when Confederate General Robert E. Lee surrendered to Union General Ulysses S. Grant. 8 months later, in December 1865, the 13th Amendment was ratified. Section 1 of the 13th Amendment provided, quote, "Neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States." Section 1 did what President Lincoln's Emancipation Proclamation could not. It eliminated slavery nationwide. However, the framers of the 13th Amendment did not trust the states to voluntarily eradicate slavery. Congress would need an enforcement power. Section 2 of the 13th Amendment granted Congress the power to enforce this article, that is Section 1, by appropriate legislation. 3 months after the 13th Amendment was ratified, Congress relied on this new power in Section 2 to enact the Civil Rights Act of 1866. First, the law provided that, quote, "all persons born in the United States were, quote, citizens of the United States." During the Civil War, President Lincoln's Attorney General, Edward Bates, concluded that free blacks born in the United States were citizens and were therefore eligible to serve in the Union Army. His opinion expressly conflicted with Dred Scott. Through the Civil Rights Act of 1866, Republicans in Congress tried to use a statute to overrule Dred Scott. Now, people of African descent would become citizens of the United States. Study Guide. Was the Lincoln administration bound to adhere to Chief Justice Taney's opinion about citizenship in Dred Scott? Was Congress? In addition to granting citizenship to the freedmen, the Civil Rights Act of 1866 guaranteed that all citizens of every race and color shall have the same right, quote, "to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, sell, lease, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property." Later that year, Congress enacted the Freedmen's Bureau Act. This law established an administrative agency to advance the interest of the newly freed slaves. It also expressly required the President to protect the very same rights of the freed slaves that had been listed in the Civil Rights Act, along with, quote, "the constitutional right of bearing arms." In April 1865, President Abraham Lincoln was assassinated. He was replaced by his Vice President, Andrew Johnson. The Tennessee Democrat came to oppose the Republicans' plans for Reconstruction. Once in office, Johnson vetoed the Civil Rights Act of 1866 and the Freedmen's Bureau Act. He claimed that they were unconstitutional because they exceeded Congress's Section 2 powers to enforce the 13th Amendment. The House of Representatives and the Senate successfully overrode both vetoes, and both bills became law. However, some Republicans in Congress shared Johnson's constitutional concerns. They and other Republicans also feared that Southern Democrats would repeal the Civil Rights Act when their representatives returned to Congress. As a result, the 14th Amendment was drafted to ensure that Congress had the power to enact the Civil Rights Act and to enshrine the rights it protected in the Constitution. That way, even if a future Congress repealed the act, the rights it protected would remain secure. The 14th Amendment was ratified 2 years later in 1868. Section 1 of the 14th Amendment has 4 provisions. First, it begins by repudiating Dred Scott. Quote, "all persons born or naturalized in the United States and subject to the jurisdiction thereof," it proclaims, "are citizens of the United States and of the state wherein they reside." Note how Section 1 of the 14th Amendment tracks the Civil Rights Act of 1866. Both ensured that everyone born in the United States, including the freedmen, were now citizens. The second element of Section 1 echoed the Privileges and Immunities Clause of Article 4. It provided, quote, "no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." But unlike Article 4 and the Civil Rights Act, the Privileges or Immunities Clause was not drafted as a non-discrimination provision. Instead, it flatly prohibited any abridgment of a citizen's privileges or immunities. This wording now barred 2 types of deprivation of fundamental rights. laws that discriminated against some citizens, as well as laws that discriminated against everyone, equally. Indeed, the phrase, "no state shall," in the Privileges or Immunities Clause is identical to the prohibition used in Article 1, Section 10 of the Constitution. The phrase is also similar to the First Amendment's command that Congress shall make no law respecting an establishment of religion. Study Guide. What rights did privileges or immunities refer to? Statements of congressional proponents of the 14th Amendment provide one source of guidance. For example, Michigan Senator Jacob Howard was the amendment's sponsor. In a key floor speech, he remarked that privileges or immunities fall into two categories. First, he explained, they include whatever privileges or immunities are protected by Article 4. On the Senate floor, he read Justice Washington's list of privileges and immunities in Corfield v. Coryell. The canonical formulation of fundamental privileges and immunities in Corfield was based on George Mason's canonical formulation of natural rights. Senator Howard then identified a second category of privileges or immunities. Quote, the personal rights guaranteed and secured by the first 8 amendments of the Constitution. He then listed all of the provisions in the first 8 amendments that protect individual rights. You will recall that Chief Justice Taney and Dred Scott also assumed that the rights of freedom of speech and to carry weapons were privileges and immunities protected by Article 4. Likewise, the Freedmen's Bureau Act expressly protected the fundamental, quote, constitutional right of bearing arms. In this way, the Privileges or Immunities Clause overruled Barron v. Baltimore. Chief Justice Marshall concluded that the Bill of Rights only limited federal power. Now, the state's police powers would also be limited by the fundamental rights in the first 8 amendments. Senator Howard's speech supports the thesis that the privileges or immunities of U.S. citizens refers to rights that are so fundamental that they are considered to be natural. This category includes those rights affirmed in Corfield v. Coryell, along with the rights that are expressly protected by what we now call the Bill of Rights. Another source of guidance about the meaning of privileges or immunities is the Civil Rights Act of 1866. It protected certain fundamental rights, including the right to, quote, make and enforce contracts, and the right to, quote, convey real and personal property. We know that the 14th Amendment was designed to protect the rights specified in the Civil Rights Act from being repealed by a future Congress. And this goal could only be accomplished if the fundamental rights listed in the Civil Rights Act of 1866 were thought to be privileges or immunities of citizens of the United States. Like the Bill of Rights, the Civil Rights Act provides textual evidence that the rights it contained were so fundamental as to be considered privileges or immunities. But wait, there's more. The third provision of Section 1 of the 14th Amendment provides, quote, nor shall any state deprive any person of life, liberty, or property without due process of law. The Fifth Amendment already prohibited the federal government from depriving a person of life, liberty, or property without due process of law. Now, under the 14th Amendment, states were subject to the same restriction. In later cases, we'll explore what the due process of law requires. The fourth provision of Section 1 of the 14th Amendment provides that states cannot, quote, deny to any person within its jurisdiction the equal protection of the laws. Let's contrast the Equal Protection Clause with the Privileges or Immunities Clause. Which of these provisions prohibits states from enacting discriminatory laws? According to modern Supreme Court precedent, it's the Equal Protection Clause. However, the text of the 14th Amendment suggests just the opposite. The Privileges or Immunities Clause bars legislatures from making a law that abridges the rights of all its citizens, as well as laws that abridge the rights of any group of citizens. Specifically, it prohibited 2 categories of legislative action: laws that deprive everyone equally of a fundamental right, and laws that protect the fundamental rights of some citizens, but not others. The Equal Protection Clause had a very different purpose. Its text does not impose limitations on the enactment of legislation. Rather, Equal protection of the law requires equal enforcement of the law. The states now had an affirmative duty to enforce the rights of all people, black and white, male and female. That is, government had to protect them from both governmental and private deprivations of their constitutional rights, including the privileges or immunities of citizens of the United States. This right of protection mirrored the Civil Rights Act of 1866, which mandated that all citizens were entitled to the, quote, full and equal benefit of all laws and proceedings for the security of persons and property. Once again, the framers did not trust the states to comply with the 14th Amendment. For that reason, they added an enforcement power. Recall that Section 2 of the 13th Amendment gave Congress the power to enforce Section 1 of that provision. Likewise, Section 5 of the 14th Amendment gave Congress the powers to enforce Sections 1 through 4 of that provision. Congress could now enact new appropriate legislation to protect a person's rights under the 13th and 14th Amendments. The original Constitution was primarily designed to empower and constrain the federal government. There were a few exceptions. Article 1, Section 10, for example, prohibited states from passing bills of attainder, ex post facto laws, or impairing the obligations of contracts. However, the rest of the Constitution, such as the Establishment Clause, only applied to Congress. Shortly after the Civil War concluded, Southern resistance to Reconstruction and racial equality exploded. The 13th and 14th Amendments greatly expanded Congress's powers to protect citizens from their own states. Furthermore, these amendments also empowered the federal courts to enforce these rights. These amendments fundamentally changed the relationship between the federal government, the states, and the people. Or at least that was the plan. Not everyone agreed that such a great departure from the original constitutional design was a good idea. Over the next 3 decades, the Supreme Court resisted this alteration to our federal system by narrowly construing each of the 3 critical provisions of the 14th Amendment. First, the Privileges or Immunities Clause was basically deleted from the text of the 14th Amendment in the slaughterhouse cases Bradwell v. Illinois and U.S. v. Cruikshank. Second, in the civil rights cases, the court limited the 14th Amendment and Congress's Section 5 enforcement power to state action. Private actors were free to violate civil rights. This case introduced what came to be known as the state action doctrine. Finally, in the anti-canonical decision of Plessy v. Ferguson, the court eventually found that the 14th Amendment allowed the government to mandate separate but equal accommodations. These decisions enabled the rise of Jim Crow, the name used to describe the regime of state-sanctioned racial subordination and discrimination that was enacted throughout the South. Critically, this legal regime was reinforced by organized private violence against African Americans. Notwithstanding the 13th and 14th Amendments, local law enforcement, that is, state actors, refused to protect the civil rights of some of their people. These decisions also inhibited the fight against public and private racial discrimination throughout the rest of the United States. The promise of the 14th Amendment was not fulfilled, but because it was enshrined in the text of the Constitution, it remained a promise that could later be kept.